Welcome to today's webinar. We are talking about powers of attorney in British Columbia, and we have with us our guest speakers, Cheyenne Reese and Hilda Deprez, who I will be introducing in just a few minutes. Before we do that, I just wanted to introduce myself. My name is Paula Price. I am with the People's Law School, and so excited to have all of you with us here today. Today, we're going to be talking, as I mentioned, about powers of attorney, and we will be going through questions that were prepared based on the common questions that our speakers receive in their respective practices. What you can expect today is we have 60 minutes together. We'll spend probably about 45 minutes answering the questions, and then we will have time for live questions at the end. What you will be hearing are answers to your questions. It is legal information, not advice, current as of today. And if what you're looking for is legal advice as it applies to your specific set of circumstances, we would encourage you to reach out to Cheyenne or to Hilda. Their contact information is on the slide, and you'll have access to that later as well. We would like to acknowledge that the land on which the People's Team is gathered is the unceded territory of the Coast Salish peoples, made up of the Musqueam, Squamish, and Tsleil-Waututh nations. We would also like to thank our funders whose financial contribution made this webinar possible. And those funders are the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation. And with that, I would love to introduce and thank our amazing speakers. They are both extremely knowledgeable in their respective fields. They know a lot about powers of attorney, and we're so excited to welcome them and to have them share their knowledge and expertise with all of us. We have lawyer Cheyenne Reese from Legacy Tax and Trust Lawyers. She has an estate planning and tax practice with a niche in US, Canada, cross-border transactions. We are so delighted to have her here today. Welcome, Cheyenne. We also have our notary public, Hilda Deprez, who is joining us from her office in Vancouver. Hilda is also extremely knowledgeable in the areas of powers of attorney and non-contentious legal matters. And we're delighted to have Hilda with us today. She contributed significantly to the questions that we'll be going through today. So thank you for being here, Hilda. Welcome. And moving into our questions, our first question is for Hilda. Hilda, the question that we have for you is, what is a power of attorney and how is it different from an enduring power of attorney?
In the most basic form to explain it, the power of attorney is a legal document by which someone grants a mandate of unconditional trust to one or more other people and says, I trust you unconditionally to either help me or, if needed, take over from me in the management of my financial and legal matters. So the power of attorney is purely NBC around financial and legal matters, and it's a mandate of trust, right? There are different powers of attorney. The most common one is the enduring power of attorney, but there are different powers of attorney, such as you can have a limited or specific power of attorney, which would be, I am going on away traveling for 3 months. I want to assign someone for that specific time or for a specific task while I will be absent. You can have a general power of attorney, which would mean I appoint this person to do any and all things as they may present themselves. But then most importantly, the enduring power of attorney is a document that you make now. You grant unconditional trust to someone from this day onward, while you are capable. And even if you ever were to become incapacitated, right, to continue to have full effect until either you pass away or you were to revoke the document. The enduring power of attorney is the most common one, because it's the one that is selected when you want to plan for the unknown that can present itself at an unknown moment in the future, right? So mostly when people ask for a power of attorney, they're thinking about the enduring power of attorney.
Thank you so much, Hilda. So just to clarify then, that enduring power of attorney is one that takes effect the moment that it is signed? Is that how that works?
The most important component is that it continues, it endures to be valid regardless of your level of ability or capacity, right? So it's a mandate of trust that is vested the moment you grant it to someone, and it keeps on going until you or life puts a stop to it.
Beautiful. Thank you very much, Hilda. Our next question is for Cheyenne. And the question here is, what can your attorney do and what can your attorney not do?
So this is going to sound quite scary because my list of can'ts is actually longer than the list of cans, but the overarching can is very broad. And that is, as Hilda was saying, the attorney can basically deal with your financial affairs in the same manner that you could. So they can almost entirely do whatever it is that you, the donor of the power, could have done. But there are some caveats, and some of those caveats depend on how the document is written. So for example, a power of attorney document will not let that person that you've trusted deal with land unless the power of attorney explicitly says so. Likewise, a person who's named as in a power of attorney can't make gifts other than relatively small gifts on the person's behalf unless the power of attorney says so. One really important one that's come up in my practice recently is we've had children with powers of attorney where one of the children wants to buy the house from, say, mom, because mom needs some cash and the power of attorney child wants to keep the house. But without specific language in the power of attorney saying that the power of attorney can get the asset, even with fair market value, that can't happen. So it's really important not only to have a power of attorney, but to make sure that that power of attorney grants the powers that you want somebody to have on your behalf, and also to not have powers that you don't want them to have, because it is a mandate of trust. And I'm stealing that phrase. I like that, Hilda. It's a mandate of trust, but sometimes you trust somebody to do sort of a bucket of things, but there's this other bucket that you'd rather they didn't participate in. Like you might not want your neighbor as your power of attorney to be able to transfer your home to them, but you may be perfectly happy with them dealing with your bank account. Another really important thing that a power of attorney cannot do is create a new will on your behalf. That's very important. The power that you retain individually, and they can do some things though that are kind of like a will. They can change your RSP designation if it meets certain criteria. So it is you want to really trust that human or trust company. It doesn't have to be a human. You can name a company to do this role for you if there's nobody. We'll come back to that. The overarching thing though is that whoever's acting as your attorney has to act in your best interest. So what can't they do? They can't act contrary to your best interest, and they can't override you if you're still capable. So if you're still capable and you say, I don't want any money to come out of this account, they can't then take the money out for you. Hilda already said they can't make healthcare decisions for you. In some jurisdictions, it covers both. You can't, there are a whole bunch of other things. But the only other one that I wanted to raise was that a person acting as attorney can't dispose of any of your assets that are specifically listed in your will as going somewhere. So if your will says my house is going to go to my child, then your power of attorney can't sell the house to somebody else or can't give it to anybody else unless it's really important for your own care. So there you go. That's a lot of can'ts.
It's interesting. So, I mean, it sounds like it's really important when you're crafting your power of attorney to make sure that you're very explicit in terms of what you're allowing them or not allowing them to do. And also, especially that last point you made about the will, having regard to other planning documents to make sure that there's consistency between all of them.
Yeah.
Thank you, Cheyenne. Our next question is for Hilda. The power of attorney is only for when I'm incapacitated. Is that right?
It is not right. That's the short answer. Even though incapacity is for most clients the driver, what motivates them to think about this document and to draft the document, it's very important to realize that incapacity is a very strong word and means certain things. Whereas, as we said already, the power of attorney is a mandate of trust. And so therefore, it's not necessarily linked to your incapacity, right? I usually refer to it to my clients that this is the documents for when we are not on top of our game or we don't have, the best day, right? And we will all have these days in our life. This can, for instance, be you will undergo surgery, maybe a sports surgery, you will have a lot of recovery. During all this time, you are completely competent and you are completely capable of doing things, but you are either lacking the energy or the mobility, or you're stuck in a hospital bed. And so you rely on someone to be in the outside world, outside of a hospital, to communicate, right, with an insurance broker, with your banker, right, to ensure that certain things are done. So even though incapacity is the motivator, a power of attorney is not requiring someone to be incapacitated as per definition, unless the document, makes, as Cheyenne was saying, unless the power of attorney document defines that would be a condition and how that is to be determined, right? So this is the document for the rainy day when we don't feel so well. Or, as we also already said, when you're going to be absent for a while, either due to traveling or work. So it's going back to that key principle. It's a mandate of trust where someone becomes your voice, your signature, your decision maker when and if needed.
So helpful, Hilda. Do people use it as a convenience as well then? Maybe they could do it, they're in the country, but they just don't choose to do it. Is that another time you might choose to make?
Yes, for sure. Actually, a lot of young people and young couples actually do this for this exact reason, especially if people have a lifestyle where they travel a lot or go and visit family or are snowbirds and will be, have a habit of being out of the country for a certain period of time. This is a perfect, convenient tool. Yeah.
Thank you.
Provided you trust the person.
Right? Yes, and we'll talk more about that. We'll talk more about that. Thank you, Hilda. Hilda, this next question is for you as well. So here we have a couple. They've got a joint bank account and they own their home together. Why would somebody in their position need a power of attorney?
I think that is probably one of the big misconceptions out there, that people feel we've been a long time, or maybe not long time, but we are a team, we have each other's back, we are together with joint accounts, joint title. So I have your back, you have my back type of approach. Even though you may view your couple and your relationship that way, the outside world, being government instances, financial institutions, insurance companies, and so on, they don't work and operate on the assumption that the person you share accounts with or a house with or a life with, that is the person that you trust unconditionally by definition, right? We are all still our own unique individual self. And when it comes to credit cards, it's your credit card. When it comes to a tax-free savings account, it is your tax-free savings account. It is your RSP. It is your income tax filing. So therefore, there's still a lot of reasons why you would have need for a power of attorney. But now specifically speaking to the house, it takes the 2 people or the 3 people on title to sell a house. It takes the 2 or 3 people on title to renew a mortgage or obtain a line of credit or sign on for the property tax deferment. You can't just speak for the other and sign for the other. It takes both people to be fully active participant, meaning cognitively completely capable to participate in the consequence of the transaction. So having joint assets does not mean you don't need a power of attorney. Hands down, no.
So such excellent insights, Hilda, and I'm just thinking about how couples out there will need to turn their mind to what types of powers of attorney or they would want to be giving to their spouses for these situations that you've described. Cheyenne, the next question is for you, and that is, what happens if I don't have a power of attorney?
Yeah, so if you don't have a power of attorney and the house needs to be sold, for example, it simply can't be unless a process is undertaken. And that process is called the nomination of committee, which is spelled committee. So you would think it was pronounced committee, but you would be wrong because that's the law. But it's a court process where somebody has to apply to act basically as your power of attorney. It can also be done for your health care. And it's long, it's costly, and if nobody steps up that the court thinks is an appropriate person, then the public guardian and trustee ends up being your committee, and they then have control over your assets, and sometimes, as I say, your person. And that is not a scenario that anybody really wants to be involved in. The public guardian and trustee fulfills a very important role, very honorable, great, but I wouldn't want them in my life. And so a power of attorney is quite a straightforward, simple document. We'll talk about that more, but it's such a simple thing to do, and to do correctly. There's really no reason not to have one, because the disadvantage of not having one is really overwhelming.
Yeah, it sounds like it. Sounds like it's really one of those ounce of prevention, pound of cure situations. Thank you, Cheyenne. The next one is for you, Hilda. Can I make my own power of attorney, or do you need a lawyer or a notary to do that?
Yes, I love this question. It's a very good question. So it's kind of like a nuanced answer, because even though technically by law, it is perfectly legal and valid to make your own power of attorney, provided you follow the format and everything else we talked about, and it's witnessed correctly. It is possible, with the exception that it would not work for any real estate transactions, right? So basically, someone that rents, has no real estate, could opt to make their own power of attorney, right, if they want to do so. However, in my experience, I can say that it's clear that oftentimes these powers of attorney are in the real world not workable. And the reason for that is multiple. Not that I know all the reasons, but I can definitely sum up some of them. First of all, the test of capacity, or in other words, like the law, the Power of Attorney Act has defined what questions, what test of capacity the person making the power of attorney needs to pass in order to make a power of attorney. And that test of capacity is extremely high. It's actually way higher than the capacity needed in order to make a will or to enter into a contract of purchase and sale of a house, let's say. So this is a very high standard. And I think it's a very protective standard, because the law recognizes you're giving someone unconditional trust. And, if that trust is breached, it can have far-fetching consequences. So they want to make sure that the person sitting in front of the notary or the lawyer, is quizzed, as to, do you understand what is this? Do you understand the consequences of that? And I think the third parties, being levels of government, banks, insurance, all of that, feel that when a document has been created by an individual just privately, there has been no gatekeeper to sort of do that assessment, right? And so they feel that this is a little bit more of a vulnerable document from the get-go, right? And then the other component is that, as we all know, because we read about this in the paper and we've witnessed, unfortunately, that, in our larger environment, there's a lot of abuse happening with powers of attorney. There's a lot of misuse happening with powers of attorney. This is something that everybody, banks and so on, sort of deal with high level of caution, right? And I think that's another reason why they want to make sure that the person granting the power of attorney was well advised and well informed, which again, when they did it by themselves, we don't know. And then there's the component, they did it by themselves, but really, did they do it by themselves? Did someone sort of say, you better give me this document, because if you don't give me this document, you know, I'll never come and take you to all your medical appointments anymore. You know, you can fend for yourself. So we don't know about undue influence. We don't know about capacity. And so because of all that, I think this proves to be not always recognized. So if someone makes their own power of attorney, you should be expecting that some instances will simply not accept it.
Thank you so much, Hilda. That's such a great point. And we had some viewers write in before the webinar talking about how sometimes it's very difficult for individuals, the attorneys, to actually have their power of attorney recognized. So it sounds to me like one of the things that you can do is to have a lawyer or a notary do the power of attorney. That way, whoever is on the other side knows that you followed this process to make sure that capacity was there, to make sure that it's not a case of undue influence. And so I think that's really great information for everybody watching who's thinking about the pros and cons of doing it on their own versus having somebody like you or Cheyenne help them do that.
And I want to add to that, just to sort of neutralize it, maybe, that even when someone goes to, you know, a lawyer or a notary to get this done, you know, banks will still vet these documents and send them to their trust and legal department. So even if it's prepared by legal people, it's even in that circumstance not necessarily taken face value and just acted upon. Just because, and we should all be, you know, it may be frustrating in the moment, but we should all be happy, because it means that, you know, there's different gatekeepers wanting to make sure that this is used under the correct circumstances, right?
Absolutely.
Can I add to that a little bit too, just as kind of more of a practical thing. I've seen self-made powers of attorney, and there are just errors. Now, that's not to say that lawyers and notaries don't ever make mistakes. Certainly we do, but they are fairly rampant. Even when people are using these forms, they're making, they're missing things that ought to be there, or they're adding things that ought not to be there. There are some typographical errors. They're naming something that they didn't think they were doing. They fail to have a backup. I mean, it's like, from a practical perspective too. I mean, Hilda's points are the better points for sure. But I would also just say, there's so much opportunity for not getting what you want by doing it yourself.
Exactly. And Cheyenne, I'm glad you added that. I think it goes back to your original point. You know, what can an attorney do? What can't they do? And wanting to make sure that whatever it is that you're intending to authorize, in fact, is what is authorized. So thank you both for your responses to that question. Our next question is for you, Cheyenne. And going to that person, when you're thinking about who you want to appoint as your attorney, what factors do you want to take into account, and can you appoint more than one person?
Yeah, so I mean, going back to Hilda's first point, it's a mandate of trust. And again, I will continue to use that because I like it. And so the most important thing is that whoever you're naming is somebody whom you trust to manage your affairs if you can't. Sometimes that's a family member, sometimes it's not a family member. But the other thing to be thinking about is, what's the relationship like between that person and your other, let's say, children, or the other people who are going to benefit from your estate? Because sometimes having, let's say, one child act as the power of attorney where there's a difficult relationship among siblings, is all it's going to accomplish is mistrust among them and a deterioration of their relationship. And to my mind, usually that's not worth it. Depends obviously on the family. And just having a financial background isn't necessarily the most useful thing. You do want somebody who's organized, who you know is going to keep good records, again, act in your best interest, and who's available. You know, it might be that you've got a nephew or a niece or something who's, you know, top bank exec and knows how all things works, but has literally 3 minutes a week that they can spend on your stuff, and that's not very helpful either. Can you name more than one? Absolutely. And the reasons you would do that, sort of relationship issues is often part of the thing, or you've got a couple people where one has is more economically or financially savvy, but the other one might be a little bit have more personal connection with you. If you're naming more than one person, though, there are a few different ways that you can name them to act. One of them is separately. So you can name child A, child B, and child C, any of whom can act separately, which means A could go off and do such and such, and B could go off and do such and such, and C could go off and do such and such, and they're all valid, which I don't like. There are very few circumstances in which I am comfortable with somebody making that decision, because A doesn't have to talk to C, doesn't have to talk to B. They could be doing things at cross purposes. I don't love it, but sure. Once I've done it like twice, and I've been doing this for an awfully long time. Another way that people will do it is making the people make decisions together. And if you've got two people, to me, that's reasonable. If you're going to make them make decisions together, I like my power of attorney to say, but only one of them has to sign for anything. So if an institution will allow just one to sign, at least they don't have to get both people to do it. That way, both people have to agree. It's obviously more burdensome than having just one person go off and do it. The third way is to have it by majority, right? So you name 3 people, 2 of them have to agree on any particular thing. I have clients who name 4 people. I really don't like that. I mean, that is so unwieldy. Nothing will ever get done, but I will sometimes get bullied, very rarely, but sometimes I will. If they're going to have 4, they're going to also have a tiebreaker, because I will not allow a stalemate. Because if you need your bills paid, or you need to, like, your care home needs to be decided upon, I need somebody to make a decision on that. So there you go. The other thing to say is, I kind of alluded to this in the self-made power of attorney, but my preference is that if somebody's naming a person to act as power of attorney, that they always have a backup, because you don't want to be in a position where that person has predeceased you or has become incapable, and then you're back where you started, having nobody. And I also alluded to the fact that you could have a trust company acting as your power of attorney. It doesn't have to be an individual. For example, most of the big banks have a trust company that they're affiliated with. They can take that on. There is a fee associated with that. So, it's one of those things if there's nobody else suitable. But Hilda's going to talk about fees later, and I don't have to. So.
Cheyenne, thank you so much. I think those are really practical suggestions on how to set up your attorney, how to do it. I love your point about the tiebreaker and not picking 4 of them, and making sure that you're selecting people so that things will actually get done on your behalf. So thank you for those wonderful practical tips. This next question is also for you, Cheyenne, and it's one that I gather comes up in your practice, which is, can I appoint somebody living in another province or another country as your attorney? And specifically, if you'd like to appoint your child and they live in the US, can you do that?
Yeah, so the answer to that is yes, but. So you can name somebody in any jurisdiction you would like. Is that very practical? It kind of depends. I mean, if you're naming somebody who lives in Nepal, time zones alone might really bog that up, right? Having to sign things, let's say the house needed to be sold, you still need a notary to be involved to sign the documents. It's difficult. If you're not in an English-speaking language, we have this problem of having to translate documents. It's kind of a nightmare that way. From an investment perspective, most investment advisors here in Canada don't have the proper securities license to take instructions from people who don't live in Canada. So for example, if you've named a child as your power of attorney and the child lives in California, like the most of them seem to do, then if you became incapable and your child now has power of attorney, they can't say to your investment advisor, sell my shares of X, Y, and Z, or my mutual fund and reinvest it in such and such. They just won't have the ability to do that. There are some US licensed advisors. I deal with them, so I know who they are, but they form a fairly small percentage of the investment advisors out there. And that's a really big problem for people who don't just have RSPs, RIFs, tax-free savings accounts, and bank accounts. In terms of a US person can absolutely be a power of attorney subject to this investment advisor problem. Any US person, and that includes a US citizen living in Canada. And I say that because There are 138 people on this call. At least 10 of you are US citizens. A US person who's got the power of attorney from somebody, if it's activated, that means that that US person has to put your accounts on their reporting to the US Treasury Department as accounts over which they've got signing authority. It doesn't cause them tax, but it means that your financial information is disclosed to the United States. And a lot of people don't want that. Now, I say, if that's the only person who's the appropriate power of attorney, and you've become incapable, do it, because that's more important. But you need to be aware of that consequence. We'll come back to this notion of things being effective later. Yeah, so those are the main things.
Super. Thank you so much, Cheyenne. This next question is for you, Hilda. And let's say that you are originally from the Philippines and you have property there, and you'd like to give your sister who lives in the Philippines a power of attorney to deal with that property. Is that something that can be done here in BC?
Yeah, so this is a question that at our office we get a lot, like the tone of this question. And it's very important for people to realize that, you know, notaries and lawyers, we can only handle within the legislation of our own jurisdiction. Like, we are not wizards that know exactly how documents in the Philippines or Australia or any other country of the world should look like, nor what the powers are, not about the format, nor about the signing requirements, nor about the contents, nor about nothing. So we cannot draft documents that are to be used outside of this jurisdiction. The advice to these people is you have to go to someone within that country, speak to a notary or a lawyer, depending on how that country is organized, but to a legal professional within that jurisdiction and say, this is my issue. Can you help me with the document that is needed for that jurisdiction? What we can play a role in, and that's where we do come in, is because the client is living here, right? Once that document is sent over from the legal professional, wherever in the world that is, to Vancouver or to British Columbia, the client can come to us, right, with appropriate ID, right? We basically go over the document, make sure they understand what they're signing, and basically we become a facilitator of the signing process. And then depending on the country of origin's requirement, it may not just stop with having the signature of the lawyer or the notary here on it. Most countries will also want this to go through sort of an authentication process or a legalization process, which is done through consulates, you know, Ministry of Foreign Affairs, and so on. And it varies from country to country. So in other words, the starting point of something like this is in the country of origin, right? And we can be a facilitator in the execution component, but the process involved is not something we do from A to Z or can facilitate from A to Z over here.
Super. Thank you very much.
Okay, if I could add just one little thing. The thing that Hilda and I can also do then is to make sure that that power of attorney isn't revoking your power of attorney here.
Yes.
Because very often if you just say, Philippine lawyer notary, prepare one for me, it's going to just say, I revoke everything and I deal with everything. So yeah, thank you for that.
Fabulous. Thank you both. This next question is for you again, Hilda. So I recently moved from Ontario to British Columbia. I did a power of attorney with a lawyer in Ontario. Do you need to make a new one when you move to British Columbia?
Also, very good question. And once again, not a straightforward or a like one sentence answer, as much as we would like that, but you know, law is never like that, which makes it so interesting. So the Power of Attorney Act does recognize extra, interprovincial, and extra jurisdictional documents. So in and of itself, it is possible, provided that certain conditions are met, which the obvious ones are, well, hopefully the one that was made in Ontario was done correctly, meets all the standards, right? The document has to be enduring, right? And then basically it has to fit with what our legislation sets, right? So it has to be valid over there, but it has to meet the requirements to be valid over here, right? And it has to be one that is, going on over the period of time. So generally speaking, when someone asks me that question, means that the client is sitting in my office and they're capable and they come to redo a will and things like that. My advice is you should basically make a new document, because this is all provincial legislation, right? Both powers of attorney, representation agreements, this is all provincial legislation, and it varies quite a bit, from province to province, to start with in the name that we give these documents. So when you are capable and you are reorganizing your life in another province, I think it's very good advice that you put all your estate and incapacity planning documents in order in accordance with this place. If, however, you move over here, but you still have a house in Ontario, you still have, an investment portfolio over there, please keep that power of attorney for that purpose. And then the lawyer or the notary over here will create new documents to fit this jurisdiction without, thank you, Cheyenne, revoking the other one, right? So they can stand, side by side, right? But that would be the advice. So in my opinion, you would only want that Ontario one to survive BC if you, God forbid, in the meantime had become incapacitated. And, we have nothing else, right? But if you are still capable, my recommendation would be to have new documents drawn up. Yeah.
Beautiful. Thank you so much, Hilda. That's really helpful. Our next question is for you, Cheyenne. What if you would like to sign a power of attorney now, but not have the person that you've named in the document to be able to use it until you need it? Can you do that?
Yeah, so I'll tell you what I do, and I'm curious to hear what Hilda does. In BC now, for a while now, a power of attorney a person named in a power of attorney can only start acting once they've signed a portion of it. So it used to be that, I would sign a power of attorney to X, Y, and Z, and then as soon as I had done it, they could kind of go and do things other than with land. But now there's a second step. So one thing that you can do is simply sign the power of attorney yourself before you're ideally a lawyer or notary if you want it to be effective for land, and then not have the people in line sign it themselves, which works fine, so long as people know where to find it and the right people know how to find it and nobody destroys it in the interim and all of that. What I do in my practice, and largely because of this US disclosure piece that I was talking about, but also because I don't trust clients not to lose the original power of attorney and then lose their own capacity, I like to hold on to them. So I actually hold on to original powers of attorney, which is fairly rare, but I have clients sign a letter, what is called an escrow letter, to me that says, you have my original power of attorney, and I want you to release it to my spouse if I tell you to in writing, or you get a letter from my physician saying I can't manage my affairs anymore. And I want you to give it to the next person in line. If those things are the case, I'd give you a letter, or you hear that I can't manage my affairs, and my spouse or whoever else is ahead of you, ahead of that other person, can't do it, doesn't want to do it, and so on. To my mind, that's the safest way to do it. Is it the most convenient for somebody? Probably not, but I think it protects people quite well. And we don't charge for holding on to them, so it's not as though people are out of pocket for what that's worth. Hilda, what do you do? Do you do that as well?
Yeah, similar. I basically, when people don't have an immediate need, they make it as a planning tool, not for an immediate purpose, then yes, my advice is always to basically stay in control, like, either myself or they themselves stay in control of the document, not to have it completely signed and then hand it over, which still surprises me, but it seems to be that most clients just have the idea, I'm just now going to hand it over to that person, which even if you want to revoke, even if something happens and you think, maybe I should, take that back from that person, if you're no longer in control of the original, it becomes quite the ordeal. So that's another reason why you want to stay in control of where that original is, and that you are in control of the person having it, being your lawyer or your notary, as to when and how it can be released. But some people also will think about springing powers. Cheyenne, did you want to say something about that?
Yeah, it's not something that I've ever done, but it becomes effective on a later date. I don't like that. I don't think it's good practice.
I don't like it either, but I just wanted to bring it up because some people bring that in as their way of sort of going around that issue, right? Like, I'm going to make a document now, but my daughter cannot use it until a doctor writes a letter that I am no longer capable, right? But I think most of us in practice don't like that.
Yeah, I think that's true. I could add more, but I think we're running tight, so I'll let you.
It's fascinating. Thank you both for all of this discussion. It's really helpful. The next question, Cheyenne, is for you. What if you want to change your mind and revoke the power of attorney? Can you do that?
Yeah, so as soon as that other person has signed the document and it's been released in the world, you'd have to give them a formal written notice that you no longer want them to act and that you've revoked the power of attorney. And that can be very awkward, setting aside anything else. That's saying to your child or your friend, I don't really want you to be my power of attorney anymore. If it's because your own kids, for example, are now old enough, that's one thing. But if it's like, we've had a falling out, or I've seen the way you've dealt with your own money, that's really problematic. But certainly it can be done. That's another reason, just if you don't release it, you don't have to deal with that, right? You can continue to change your mind. If you revoke a power of attorney, you need to tell any institution that knows about it, a bank, land title office, whoever knows that the thing exists, you'd want to tell them.
Okay, excellent. Thank you, Cheyenne. The next question is for you, Hilda. How do you know that you can start acting as, sorry, I didn't switch the slide over. How do you know that you can start acting as your mother, in this case, appointed attorney? Who will tell you that it's up to you to take over paying the bills?
So it goes back to the beginning that we've said over and over. It's a mandate of trust. Right. So you have a fiduciary duty, you have a duty to act within that mandate. And so therefore, when does it start? When you are the appointed attorney, you can act only either if the individual asks you, right? Says, could you please do this for me? Or if you feel that this person is now lacking the ability or capacity to sort of do it themselves. Right? So there is nobody coming to your, ringing the doorbell saying, this is the moment. There is no one going to issue a piece of paper saying, here you go. This is basically the onus, the difficulty is on the attorney to decide, is this the moment, right? And this can be very tricky because it can be very gray zone. And it can cause a lot of tensions when a parent, for instance, starts having short-term memory challenges, and the child is well-meaning and thinks, I should take over paying the bills because mom is going to start forgetting paying them. But mom is still completely capable for a whole lot of other things and feels that the child is stepping, into her life too much and is pushing her out. And it's not easy. But there is nobody there to really guide or initiate that transition. It's again between the two people within that mandate of trust that hopefully have good interpersonal relationship.
Fabulous. Thank you so much, Hilda. And one thing that I wanted to note is, and there's links, and we'll give these links in with the recording of the webinar, but there's information on our website as well about for the attorneys so that they know what to do and what that role involves. So we've got that resource for people as well. The next question is for you, Cheyenne. We've just got a couple of questions before we're going to turn to the live questions, which is, here we have a situation where a father appointed one son to as his attorney under his power of attorney, and the son's looking after the banking. And then the other son, the brother, starts insisting on having a detailed overview of what the other brother is doing. So In that case, does the attorney have to share anything if he was the one, after all, who was appointed as the attorney?
Right. I mean, the person who's appointed as the power of attorney has a duty to keep an accurate current list of assets, liabilities, has to be able to keep track of payments that have been made and debits and credits to the account and all of those sorts of things. And at some point is going to have to give an accounting. So, you know, you don't have to give it all the time, but you will end up having to give that accounting. So that's, you know, kind of the gig, right? And this is a job. It's a part-time job to be somebody's power of attorney. And it's really important because you have to be able to show that you've acted on that person's, in that person's best interest. I just wanted to say one quick thing because it's kind of connected to this and also a couple other points that we've made, that if you've released the power of attorney to somebody and the bank knows about it, they've been given a copy of it, sometimes they won't let you continue to act on your own behalf, even if you're still capable. So I just caution people against giving that power of attorney and releasing it like to particular institutions before you're ready, because I've had clients try to go to the bank who are still capable and not be able to deal with their own assets because the bank sees that there's a power of attorney on file.
Super. That's another cautionary tale. Thank you, Cheyenne. This is very helpful. So Hilda, this next question is for you. And after I ask the question, I'm actually going to unshare my screen so I can see some of the live questions that are coming in. So don't be alarmed when this slide disappears. But the question for you is the attorney entitled to compensation?
Yes. The attorney is entitled to compensation, which is now possible since the law changed, I think, in 2012 or something like that. Before, it was absolutely not possible because they were so worried that the person would have their hand in the cookie jar and just serve themselves that it was an absolute no-no. Now it's recognized that this is possible, provided that the power of attorney document specifically provides for it and not just says that the person can be compensated, but it has to say how, or like it has to be more defining as to how you view that compensation. Is it just reimbursement of time and expenses? Is it an hourly rate? Is it a percentage of what you are managing? How will that be done? So in other words, compensation possible, but it has to be documented. And as Cheyenne referred, we also have professional powers of attorneys, which are like trust companies, and they will make a compensation agreement, which is part of the document in and of itself. Right.
Thank you very much, Hilda. So looking at the live questions, the first question that we have here is, how much does a power of attorney cost? And I'm wondering if either of you is able to offer sort of a ballpark figure, recognizing that it probably really depends on what's being asked for.
My office doesn't generally do just powers of attorney on their own. So it's generally part of a larger estate planning package. So I don't really have a way of answering that in a great way. Hilda, do you have like a fixed fee for POAs?
I don't have a fixed fee. I wish I could say yes, because I appreciate that this for the public and for our guests would be better. But just because they come in so many different shapes and forms, do I have to spend a lot of time on capacity questioning or sort of establishing, or is it, you know, a young person coming in to say, I'm leaving on a business trip, I want this? So it all changes. I would say that probably most of us go by the time spent and the complexity involved. So I would say that unfortunately, this is not necessarily a cheap thing. This is not sort of take it off the shelf, here you go. But different members in the community provide the service at different rates. So even if I said something or Cheyenne said something, it's wildly different, you know, everywhere you go. Yeah.
Absolutely.
And it's again, I mean, this is coming from a legal professional, and Hilda feels the same way, but there's you paying this amount now to get it done properly will save everybody an enormous amount of time and money down the road.
Exactly. So it sounds like it's really something that you'll want to ask around if you're thinking about making a power of attorney. It's contacting a lawyer, a notary, and giving them a bit of information so they can give you a more give you an estimate that's based on what you in particular are looking for. This next question, maybe I'll ask you, Cheyenne, what's the difference between an enduring power of attorney and a representative agreement?
Representation agreement. A representation agreement deals with healthcare. There is one kind of representation agreement that can be signed by somebody who is already incapacitated, and that particular representation agreement will allow the representative to engage in some financial transactions. But generally speaking, for somebody who's capable, one would have a representation agreement dealing with healthcare and personal care decisions, and powers of attorney dealing with financial transactions. They can name the same people, they don't have to.
And I would encourage anybody who has questions about the difference between a power of attorney and representation agreement to join us on November 23rd. We'll have another session where we talk about representation agreements, so that will allow you to know even more about what you can do with that type of arrangement. Thank you, Cheyenne. The next question, Hilda, I'll turn this one over to you. What happens if I don't have anyone I can trust as the attorney? Where do I turn?
It's a very difficult question, and I get that a lot, and I think we will get this more and more moving forward. This will become more of a need. I would say if you don't have someone you trust, then unfortunately the answer would be don't make a power of attorney, because it's so absolutely essential that you have a person that you can not lose any sleep over, right? You know that this person will do the right thing. The alternative is, of course, to appoint corporate attorneys, as we were mentioning. But that may not be an option for all clients and members of our community, just because of the compensation fee and sort of the relation, the economic relationship that is required there. So I wish I had a good answer, but there is none, except for hoping that you would never need it in your life, and that if you ever need it, then knowing that there's still the public guardian and trustee who upholds the mandate to take care of the ones who can't, sort of protect themselves, or who are vulnerable, and then that's probably the better option, right, than choosing the wrong person.
Thank you so much, Hilda. And I just wanted to acknowledge all the questions that are coming in through the Q&A. And we're going to get to a few more questions, but we will not be able to get to all of them. So I'm going through them in order of which ones are the most, have the most votes on them. But I just wanted to acknowledge everybody who did submit questions, and thank all of you for your participation today. So the next question, and Cheyenne, this might be a question for you. It involves the public guardian and trustee. So the question here is, the public guardian trustee can cancel powers of attorney without going to court. How can they justify that power, and what are the limits?
So if there's a dispute over who's an appropriate power of attorney, there's always the option to do this nomination of committee, or making a committeeship application, and that will override both powers of attorney and representation. There has to generally be some harm that's been seen, or that there's a concern about it, or usually it's there's a dispute among which family member or other person ought to have control over that individual. It doesn't happen all that often. That's what I would say, which is a great thing. And if you thought that it might happen in your particular family circumstances, there is a document that you can sign called a nomination of committee, which basically gives evidence. If there is a committeeship application, this is the person, or these are the people whom I would want to have appointed. So at least you've turned your mind to it.
Super. Thank you so much, Cheyenne. This next question, Hilda, I'll ask you, but Cheyenne, I also welcome your thoughts on this. I am the medical representative for a friend who went into long-term care last year. The power of attorney and representation agreement were both prepared by a lawyer, yet when the power of attorney went to the bank with the power of attorney agreement, when the power of attorney, so I gather the attorney went to the bank with the power of attorney agreement, the bank insisted that they had to meet in person with the gentleman to whom the power of attorney pertained in order to comply. What is the point of having a power of attorney in place if the banks won't recognize them?
Well, the most of the banks, I think, over time, because of what they have seen, the good, the bad, and the ugly, have created their own internal protocols as to what they feel is a protective measure, right? To weed out as much as possible abuse and misuse situations, because they have a legal obligation and a contractual obligation with the account holder who's their client, right? And so it is from that perspective that they have, I think, the right and the mandate to sort of do that extra vetting, if you will, and assessment on things. As now banks constantly have a change of staff and so on, it's no longer as it once used to be that they know exactly who's who and who are the members of your family and what's the dynamic. I mean, we're all not interconnected that way, so they can't just work on assumptions. And but I would say that even though it's very commonplace that all of these players have their own check and balances, at the end of the day, normally it comes back 2 weeks later or so on, and it's a functioning situation.
Thank you very much, Hilda. That's really helpful. I'm going to ask one last question. Cheyenne, I'm going to direct this one to you because it's a follow-up on one of the questions that you had answered earlier. Is it wise to have more than one power of attorney, or are the attorneys obligated to confer with each other?
If you're naming them individually, like in order, then no, they don't have to confer with one another. If you've said, I want to name A, B, and C separately, they also do not have to confer with one another. It's really about how, again, goes back to how the document itself is drafted. So if you're naming more than one person, generally speaking, my preference would be that they at least have to talk to one another, and so that they're on the same page and they're not doing things at cross purposes.
Super. Thank you so much, Cheyenne. And thank you so much, Hilda. That is our webinar for today. Hilda, Cheyenne, thank you so much. Do you have any words of wisdom for our guests?
Get powers of attorney.
Yes, I would say the same thing. Yeah.
There is information on the People's Law School website as well on these topics. And so we've got a link here, and there will be more links in the notes that accompany the recording. So thank you again. Thank you everybody who joined us here today. Have a wonderful Tuesday afternoon, and we hope to see you again on November 23rd when we talk about representation agreements. Thanks, everybody.
Bye. Thank you.
Bye.